Hey, what's up, everybody? I have an update on Lori Vallow Daybell. With that being said, let's get it. And shout out to Hidden True Crime.
We had a quick update on Lori Vallow Daybell. If you'll remember her Wednesday pretrial hearing on May 14th, it's in preparation for the Doomsday Mother's third criminal trial. Yes, her third criminal trial, before she faces charges of conspiring to murder her ex-nephew-in-law, Brandon Boudreaux. And how could you forget this most recent hearing after Judge Boreski channeled his inner Nancy Joe by responding to Lori's demand that he recuse himself from her case and asking if she was done yet.
Are you done? Are you done? Are you just gonna keep? Are you done?
The term "are you done" has quickly joined "don't flatter yourself" as some of the best phrases coming out of Lori's multiple murder trials and hearings. And so to remind you of one of the main motions that Lori argued that day, minus her failed attempt at removing Judge Boreski, was a motion she filed declaring that she shouldn't have to wear a rack belt. Now, a rack belt, an RACC belt, also known as a stun belt, is something Lori has been ordered to wear by the judge as she represents herself in this third upcoming trial. Now, since Lori, a convicted murderer, doesn't have to wear shackles or cuffs as she represents herself, wearing a rack belt seems like a decent compromise to me. She also gets to wear street clothes, and the belt goes under the clothing and is not visible to the jury or those watching the trial from home on our Hidden True Crime live stream. We cannot see this rack belt. We just know it's there. So while Lori's motion requesting, or AKA demanding, that she should not have to wear this rack belt, while this motion was new this day for this recent pretrial hearing, this was far from the first time that we have seen Lori argue this issue about the rack belt. We first saw it come up at her previous trial during jury selection, just before her murder trial, where that jury of her peers found her guilty of conspiring to murder her then husband, Charles Vallow. Take a listen.
One more thing, Your Honor. I wanted a clarification. In your minute entry dated the 25th regarding the defendant's motion to remove restraints. So my understanding when I read what was from MCSO, and then you put in here, however, at the sheriff's discretion, one or more armed sheriff deputies may be positioned near the exits. So what their recommendation was the minimum amount of restraints, meaning if there was going to be an armed guard, then they would not have to do the belt. So I was confused by and wanted a clarification on what you were actually ordering, because the DOs had a question about it with me this morning. So
I ordered that you don't have to wear the leg restraint, but that you do have to wear the rack belt, because that is not going to be visible to the jury. The leg restraint's a little more cumbersome and visible, and since you're representing yourself and you're going to need to approach the podium and those sorts of things, I ordered the removal of the leg restraint. You will, though, wear the rack belt. And then I said it's up to the sheriff's office if they want to. They can position a couple deputies in the back if they want additional deputies.
well, their recommendation was that you wouldn't have to use the belt at all if they had the armed guard.
I read their response and their recommendation, and that's my order.
So what is it exactly?
That you have to wear the rack belt but not the leg restraint.
Well, that same judge, Judge Boreski, let her know then that she indeed needed to wear a rack belt if she wasn't going to be shackled. And indeed, she wore a rack belt during that entire trial. No one seemed to notice. I couldn't even really tell. Even though I knew she was wearing one and I was sitting in the courtroom not far from her, I never saw the rack belt. And even though we learned at this most recent hearing that at one point a belt strap had slipped down behind her jacket and they discreetly excused her to fix it, I still did not see it. Take a listen.
There was one incident during the trial where you asked to take a break because a strap was hanging down behind your jacket. We did that. We rectified the situation. There's been no indication whatsoever that the jury notice the rack belt or anything like that. So I think those conditions are appropriate and will remain for the second trial.
Your Honor, the jury was not told to see if they noticed anything either. Was that correct?
Right. There was no request for that.
The jurors during that last Arizona trial also did not seem to notice the rack belt as well, according to those I interviewed and asked if they knew she was wearing this stun belt. Yeah, could you guys tell if she was wearing a rack belt or a shock belt? Did you know that?
No.
Did you know that?
I noticed she was wearing the same things, like rotating her shirts, but wearing
Right.
the same.
Yeah, you noticed that. Same
Yeah.
suit, different day, right? Rotate. But so yeah, and none of you could see that she was wearing this rack belt underneath.
No.
She wasn't cuffed and she didn't have shackles on, so the judge ordered.
No.
She was not happy about that, by the way. The judge ordered,
Really?
yeah, that she wear this rack belt under her clothes. It's a shock belt, and she argued that very much. She was not happy, and the judge said, "Well, it's what we're gonna do." So
Right.
you can never tell.
No. I can
Yeah.
never tell.
Well, in Lori-like fashion, she doesn't give up. She clearly thinks she is always right. She knows better than the judge. She knows better than law enforcement, and she doesn't take no for an answer. And somehow, the idea that she should not need any restraints, despite having so many murder convictions, she's now hit serial killer status at this point. She thinks that she is just fine to only need to have a guard at the doorway, security. And at this point, she is going to keep fighting. Take a listen to Wednesday's hearing as she argued once again this new motion one more time.
All right, then we have the defendant's motion for no restraints in trial dated May 6th. I don't know, in your motion, I don't know where you get the idea that the sheriff's office recommendation ever was that you have no restraints at all. Their minimum recommendation was that you wear a rack belt.
Well, I have it right here and I copied it verbatim.
Yeah, you said, what it said was my recommended minimum requirements as listed above, and those were to wear a rack belt.
It said, or the recommendation of MCSO was that they could have a unarmed detention officer and an armed deputy sheriff if I was to not have any restraints.
Right, but that wasn't their recommendation.
This woman does not
I
learn.
received, the defendant's motion, I received non-party Maricopa County Sheriff Jerry Sheridan's response.
On the MCSO security justifications, my understanding is that was his recommendation.
Your Honor, Joseph Behill for the Sheriff's Office.
Oh, okay. Well, I'll deny the motion from the defendant. The same conditions will be set that we had in the first trial, that being you wear the rack belt, no leg brace. There was one incident during the trial where you asked to take a break because a strap was hanging down behind your jacket. We did that. We rectified the situation. There's been no indication whatsoever that the jury noticed the rack belt or anything like that. So I think those conditions are appropriate and will remain for the second trial.
Your Honor, the jury was not told to see if they noticed anything either. Was that correct?
Right? There was no request for that.
And once again, denied. But did you hear that guy who stood up and introduced himself for the Maricopa County Sheriff's Office? And Judge Boreski basically responds to him as, yes, thank you for being here, but no need to argue. Pretty much saying, look, I've got this, but thank you. Well, what we didn't know at the time of this hearing was that the Maricopa County Sheriff's Office had actually responded in writing with their thoughts about Lori's motion. And while Lori claimed that their recommendation, the Sheriff's Office's recommendation, was that she did not need a rack belt, what they came back with in their filing was pretty much the opposite. And this came down after the hearing to clarify exactly what was recommended so that Lori can't just put words in their mouth and claim that they ordered that she didn't need to wear it because, again, that's what she claimed. She claimed there was an order, an actual order from the sheriff's office that the belt was unnecessary. So let's read what the sheriff's office actually really recommends. And I'll read it here. Quote, after reviewing defendant Lori Daybell's motion dated 5/6/2025 regarding the removal of her rack belt during her trial, I have the following response. The Maricopa County Sheriff's Office, or MCSO, requests that the rack belt remain in play during the trial. MCSO disagrees that the rack belt can be seen under the clothing.
Oh, jingle bells, jingle all the way. Oh, what fun it is to...
MCSO disagrees that the rack belt can be seen under the clothing. This device has been used for over 2 decades by Maricopa County Sheriff's Office when inmates take part in their trials, and there has never been, to my knowledge, any evidence to date that a juror has been able to see or notice the rack belt around the defendant. While the belt is likely uncomfortable, isn't that great to hear? While the belt is likely uncomfortable, it does not violate due process or prevent a fair trial. Daybell is correct that the rack belts are universal and designed to fit a wide range of defendants. However, excess slack from a smaller size defendant does not stick out in any noticeable way and is tucked inside the belt line to hide it. Daybell claims there have been many issues with detention officers trying to fit the belt on her. I personally observed the belt being put on her once during her last trial and watched as the female detention officer secured the belt to her waist in under 2 minutes. It was my observation that the detention officer had no difficulty installing the belt. Maricopa County Sheriff's Office has staffing concerns with having an armed deputy posted in the courtroom during her entire trial, and as that would be one less deputy available to respond to other demands, warrants, and other calls for service throughout the court complexes. The Maricopa County Sheriff's Office Court Security Division is currently understaffed and operates at less than 50% staffing capacity. It's frightening to hear, but while Maricopa County Sheriff's Office staffing is not the defendant's problem, it is nonetheless an issue of concern for Maricopa County Sheriff's Office and overall security with the court complexes. Maricopa County Sheriff's Office therefore requests the defendant to continue to wear the rack belt in her next trial. Boom. In defendant Daybell's second motion, she requests additional time to meet with her legal team. I have met with Court Operations Command, and we have agreed that Daybell can choose to remain in the courtroom with her legal team during court proceeding breaks rather than return to wait in her holding cell. For lunch breaks and other times of recess, if she chooses to meet with her legal team, Maricopa County Sheriff's Office agrees to transport her to level 4 of the South Court Tower. There we have a built-in visitation area normally used for EDC courts with secured legal visitation rooms. We will provide her with her sack lunch, and she can spend the entire lunch break conferring with her legal team in this room. In addition, because this visitation room is in a secure area, that she can be unrestrained, end quote. So, let's read this line one more time directly from the Sheriff's Office. Quote, the Maricopa County Sheriff's Office therefore requests the defendant continue to wear the rack belt in her next trial, end quote. Now, let's listen to Lori's words one more time, what she claimed on May 14th. Take a listen.
It said, or the recommendation of MCSO was that they could have a unarmed detention officer and an armed deputy sheriff if I was to not have any restraints.
Right, but that wasn't their recommendation.
Y'all, I will never understand the mental gymnastics that Lori forces us all to go through, ever. But I guess that is why she's behind bars. But as always, luckily, criminal psychologist, Dr. John Mathias is my co-host, a co-host I'm married to, so I get to pick his brain at every hour of the day. And John does seem to have a better grasp of what is going on in Lori's brain than I do. And a couple of nights ago, I was able to ask John all about the now infamous pre-trial hearing with Lori that I attended. And I will say Dr. John made some solid observations. I'll have you guys listen to this one.
I wish, you know what I wish you had told her when she said that after
What?
like everyone's getting everyone on the planet? I wish you had said, don't flatter yourself.
You wish that he pulled a real Nancy Joe. All right, well, that was one of my favorite moments from our bonus episode, available now on Apple subscription or patreon.com/hiddentruecrime. If you want to see or listen to that full episode, you can head to
my
Apple
foot's
Podcasts or to
Come on, wake up, foot.
patreon.com/hiddentruecrime. A link to that bonus episode with John describing what he thought was going through Lori's mind during this pretrial hearing is also pinned in comments or in the description of this episode. Make sure to check it out, and thank you to those who support us by subscribing to our bonus episodes. It's a place we try to give back to those who support us, and it means a lot. I plan to cover Lori's upcoming trial, her third trial, in person from the Maricopa County Courthouse, and we will have a live stream of the trial here at Hidden True Crime, as well as live from the courthouse at lunch and nightly live recaps in the evening. Brandon Boudreaux, to remind all of you and get you up to date, Brandon Boudreaux was shot at after returning home from dropping his children off in 2019. The bullet through the driver's seat window of his car while he pulled into his own driveway and missed his head by inches. Police have said that the gunshot, came from a Jeep Wrangler that was being driven by Alex Cox, Lori Vallow's now deceased brother. After the attempt on Brandon's life, Brandon's own children were deemed dark, just like Tylee and JJ had been, and he had to take his kids into hiding with him. While he was hiding at his parents' home with his children, police body cam footage from Utah actually shows Alex Cox and Brandon's now ex-wife Melanie attempting to trespass and get his kids from Brandon's parents' house. JJ and Tylee at this time had already been murdered at this point. I still get chills thinking about what would have happened if Alex Cox had been able to take the children from that house. It has been nearly 6 years awaiting justice for Brandon since the shooting that nearly took his life. Brandon, just to update all of you, he finalized his divorce to his ex-wife, Melanie Pulowski, who is Lori Vallow's niece, and he has found love again. He deserves all the happiness in the world, and let's hope that this horrific chapter for him and his entire family can have some closure. If you want to understand this case, the specific case about the shooting of Brandon Boudreaux, or the attempted murder of Brandon Boudreaux, in better detail before the trial begins next month, we have a full playlist starting with the complete backstory of Lori Vallow, as well as an exclusive interview with Brandon's friend Jess that I really recommend. It explains the horror that she felt. We will also have the pre-trial hearing that we just talked about and any additional trial prep. A link to that playlist is also in the description of this episode and a pinned comment. Next month, I have 2 hopes for next month's trial. May Lori's racked up be very uncomfortable, and may justice be served.
That's it. It didn't go to the next one. Okay, let me go to the next one.
If you often have trouble sleeping, experience many dreams, and suffer from neck pain, it might be time to change your pillow.
Just when you thought I was done talking about Lori Vallow for the week, so did I, honestly, but surprise, she's back, and so am I. Why? Because Lori apparently cannot resist the spotlight, and this time I have her response to the state's response to her motion for a retrial. Confused yet? Buckle up. Quick recap. A couple weeks ago, Lori filed for a retrial claiming jury misconduct. Why? Because one juror, Carl, juror 15, allegedly said he felt sorry for Lori having to serve 3 life sentences. Lori took that and ran it straight to the courthouse, insisting Carl must have known about her Idaho murder convictions. The state clapped back with a solid yeah, no, pointing out that Carl, who also gave an interview to Hidden True Crime, has always said he knew nothing about her past until after the verdict. And now, in true Lori fashion, she's firing back at their response. It's drama, guys. It's delusion. It's Lori in high definition. And friends, this latest filing, pure gold. She's mad, and she wants everyone to know it. And she throws shade at hidden true crime. So grab your popcorn. Lori's putting on another show, and we'll read it all together right now. Lori starts off on a religious high horse, beginning her response with this statement, quote, "The prosecutor, Trina K, simply stating that she did nothing that violates rules and laws is not an acceptable remedy for what is reality," end quote. So we're only one sentence in, and I already have to stop reading after that first line. Did Lori really just accused prosecutor Trina K in her opening statement of not being grounded in reality? Let that sink in. Lori Daybell telling prosecutor Trina that Trina isn't facing reality. If that's not the biggest case of projection,
Really, Lori?
I don't know what is. I'll go on. Lori is about to get into her rights, the defendant's rights. So here we go. Quote, "This defendant's rights to choose her religion and right to interpret that doctrine are legally and federally protected rights. This defendant's religious beliefs are not fodder for this court to use against her. This defendant's protected from persecution by the Constitution of the United States of America. This defendant's interpretation of her religion is not a subject that this or any other court has the right to dismiss or discredit or use against this defendant. Clearly, during this trial, the judge, as well as the prosecutor, violated the Religious Freedom Restoration Act, 1993, and this defendant's right to be free from bias and prejudice." Trina K continually raised this defendant's religion and interpretation of religious doctrine throughout the trial. Ms. Trina K questioned non-expert witnesses about this defendant's religious doctrine and interpretation of that doctrine. Ms. K made repeated references to her own assumptions that this defendant had misinterpreted the Mormon doctrine, end quote. So Lori goes on to write, quote, "This defendant is guaranteed to be free of government persecution, bias, or interference of my religious beliefs." Pause really quickly. It gets confusing because Lori refers to her as this defendant, but then she'll say my. So she is saying this defendant is guaranteed to be free of government persecution, bias, or interference of my religious beliefs, referring to her, the defendant. It is a fundamental, inalienable right. That right is not subject to the practices promoted in Maricopa County courtrooms, which clearly considered both this defendant's religion and interpretation of that religion to be subject matter that played a determining factor in how the court treated this defendant, exerted authority over this defendant's self-representation, and ultimately, and most significantly, promoted my prosecution. All were protected, all were violated, end quote. So, okay, let's stop there for a second. It is true that the United States Constitution protects religious freedom, but nowhere does it say someone can murder someone in the name of religion. Religious freedom doesn't make that okay. And Lori seems to consistently forget this thing called evidence. Religion can absolutely be a subject matter that played a determining factor and promoted her prosecution if her religion is seen as evidence of murder. Lori, no one is saying you can't believe that you're a translated being or that you were married to Chad in a past life. You do you. That's your religious freedom. But if, in your translated state, you decide you're going to be like Nephi and kill your husband because the exorcisms aren't working out for you, and you think Charles is a zombie and you're a goddess on a mission, and these beliefs show themselves in texts and conversations you participated in, and then your husband shows up dead because of, your religious beliefs, that isn't protected under religious freedom.
It don't.
That's called murder.
Thank
and your
you.
belief system shows us motive. It's just maddening, but okay, I will go on. Lori continues, quote, "The court cannot force this defendant to defend my doctrine or my interpretation of doctrine as a means of proving their case in chief. Okay, full stop again. Yes, they can. The court can absolutely use your strange beliefs as evidence in this case if they are indeed evidence. Lori continues, quote, this court has done this under Judge Boreski's supervision, considering the brevity of the misconduct that was publicly broadcast from the courtroom for anyone and everyone to see. We understand why Ms. Trina Kay and Judge Boreski would grasp at any straw available to contradict and dismiss their behavior as typical and commonly acceptable within this jurisdiction. Herein lies the overarching breach of a right to a fair and impartial trial. The trial craft continues. Adherence to the moral, ethical, and legal practice of law envelops all of the violations named in the motion for new trial, as well as those that were witnessed by all on court TV. There is no valor in intentional wrong prosecutions. There is no victory for justice. The defrauds its position behind the motivation of self-interest. End quote. And okay, that last line was gobbledygook. Now she just wants to hear herself talk, I swear. Let's, honestly, read that last line one more time. Quote, there is no victory for justice when the government defrauds its position behind the motivation of self-interest. If that's not a line made with refrigerator poetry magnets, I don't know what is. You might remember that in Lori's first filing, she cited juror misconduct as her first reason she deserved a new trial. And if you didn't remember, I'm reminding you now again. Juror 15, Carl, stated in a TV interview after the verdict that he'd felt sorry for Lori, realizing she had 3 life sentences. And many felt Juror 15 implied he'd known about her 3 sentences prior to the verdict, which still wouldn't necessarily equate to jury misconduct if he did, but nonetheless, that was Lori's argument. And here's what Carl originally said directly after the verdict. Take a listen.
Do you remember your reaction learning that she had been convicted of killing her 2 children?
You know what? I feel sorry for her. I mean, driving home yesterday, it's like, God, she's spending the next 3 lives in prison in a cell. You know, I mean, you gotta feel sorry for her, even though, I mean, that's an awful thing to do. I mean, there's something wrong up there, but he's saying still, just feel awful about it.
And here is what he said in his interview with us, Hidden True Crime. Take a listen. Clarify, you don't know how you knew that there might have been another sentencing, everything's a blur. I do understand that. Sometimes I forget what day, it is when I'm attending trial, reporting out of trial. But you did not know about any of the other murders until after the verdict.
Right. Yeah, I had no idea of anything else that she had been through prior to this trial, and even during the trial, I didn't know that.
And remember, Carl was the holdout. Carl wasn't going to convict Lori initially. Carl thought Lori was innocent, but with Trina Kay's closing arguments and the convincing of his fellow jurors, Carl eventually realized she was guilty and came to that verdict with the rest of his fellow jurors. And in response to Lori's claims of jury misconduct, due to this line shared by Carl in a media interview, the state came back saying, quote, there was no juror misconduct, end quote. And well, now Lori has come back in her response, with an entirely new reason that she deserves a retrial with regards to the jurors. Now Lori is claiming she is, quote, entitled to a new trial because the jury received and consulted extraneous evidence, end quote. This is brand new. So this is new, and you can't just do that in a response, by the way, to a motion. You can't just throw out another brand new, entirely new reason in a response. That's rather a whole new motion. But Lori's never been a rule follower, and for her argument on this point of Juror 15, or Carl as we know him, this is what she says. She states, quote, after 2 days and multiple media agencies aired Juror 15's statement, he came forward to recant on a podcast, Hidden True Crimes, not a reputable media agency, end quote. Well, to that I have to say, well, Lori, you're not a reputable goddess, nor a reputable mother, nor a reputable attorney. But nonetheless, Carl, Juror 15, chose Hidden True Crime, not crimes, but crime, to share his experience as a juror, and it was not to recant anything. And while you, Lori, have been convicted of crimes plural with an S, meaning many, many crimes, we are a reputable true crime, no S podcast. But I'll go on. Back to Lori's response. Quote, in the interview with Hidden True Crimes, Juror 15 allegedly Googled Lori Vallow after admonition, yet again incriminating himself, end quote. So I'm going to stop there again. Lori just said that Carl Googled her name after the verdict, which is actually what Judge Boreski recommended to all of the jurors. He said, hey, before you walk outside,
That's common
why
sense
don't you
after the
Google so you
case
can understand a little
ended.
bit more. So this would not be incriminating if the judge asked the juror to do this, but I'll go on. Lori now jumps into cell usage. So, quote, further, Juror 15 and other jurors were instructed repeatedly by Judge Boreski to refrain from use of cell phones in trial. Yet Juror 15 had, during the trial, be advised, guys, this is her, not me, so Juror 15 had, during the trial, be advised that he cannot use his cell phone during the trial. In a criminal case, prejudice may be presumed from any private communication, contact, or tampering directly or indirectly. State v. DeVolt, 207, Arizona, 2004. The motives for concealing do affect a juror's impartiality, can truly affect the fairness of trial. The extraneous prejudicial info was improperly brought to the jury's attention. Info is deemed extraneous if it derives from a source external matters, including publicity, and info related specifically to the case the jurors are meant to decide. In State v. Miller, a judge erred in not conducting further inquiry in the integrity of jury verdict by taking testimony or questioning jurors, even though prosecutor represented that outside conduct did not influence the verdict. In Miller, improper influence of even one juror taints criminal verdict. The judge must consider surrounding circumstances and additional juror testimony, and the judge must err in favor of the defendant. The presence of a biased juror cannot be harmless. The error requires new trial. End quote. So again, Carl was the holdout in this jury. His bias, if any, was that he thought Lori was innocent. And while what I just read is poorly written, very poorly written, without any periods, thus I can't exactly figure out where one thought begins and another ends, it seems to me as if Lori is implying that when Carl was caught texting someone one day in court, she simply assumes he was instead Googling Lori's name, not texting his daughter, like he said, but Googling Lori's name without any evidence to back this up. And what Carl actually told the judge that day, many have brought it up, was that he was texting his daughter, that he would pick her up. And I do know that Carl is a single parent raising children alone. He had also mentioned he was a widow during the trial, and he also told the reputable Hidden True Crime that he had not wanted to be on a jury because of his other responsibilities, which included his children. I am not excusing Carl for texting on his phone during the trial, but I am just giving context. There is no evidence that Carl was Googling anything on his phone in that moment that he sent a text in the courtroom. Carl then came clean to the judge and explained he was telling his daughter that he would pick her up. Lori, don't flatter yourself. Carl wasn't Googling you. Moving on. Point 2. What Lori originally cited as preclusion of Tylee Ryan and Alex Cox's statements and impermissible expert testimony by Detective Danielle Coons, she is now citing preclusion of Tylee Ryan and Alex Cox's statements. And because the court allowed expert testimony without a ruling, this defendant is entitled to a new trial, according to Lori. So in this section, she writes, quote, Detective Coons did in fact utilize certain aspects of the statement of Tylee Ryan and Alex Cox to determine the alleged expert testimony. Forensic ballistic and bullet trajectory analysis is highly technical, are subject to peer-reviewed research and to degree of standardization. Ballistics testimony requires specialized expertise. Police practice expert is not qualified to give such a conclusion as an expert. This expert is not trained in ballistics and thus cannot analyze the trajectory of bullets fired. Federal Rules of Evidence 702 should be applied consistent with the liberal thrust of the federal rules and their general approach, a mandatory presumption, which shifts the burden of persuasion by requiring the defendant to establish affirmatively the negative of an element of the offense is unconstitutional, end quote. I have to admit, I don't know what she just said. The grammar's bad, the wording's confusing. Part of me wonders if I just don't understand legalese, but I actually think this is about me not understanding Lori-lese. I think she's saying that Detective Coons is not an expert witness, thus he shouldn't be used, something that she's argued multiple times before. And Lori's third reason for why she should get a retrial was what she deemed as a discovery violation. Lori had essentially claimed that while the state produced the gray key information for Charles's phone during the trial, that is the cell phone extraction, the defense, aka Lori, had been requesting her own extraction of Charles's phone. We know that she has really wanted her own extraction of Charles's phone. But Lori was not able to complete this extraction in time to use during trial, and then claimed that the gray key extraction is considered exculpatory evidence. So evidence so damning that it would prove her innocence. That's how important this gray key extraction is, yet she wouldn't waive her right to a speedy trial, that she could have time to get this evidence. Nonetheless, the state came back claiming there was absolutely not a discovery violation. Lori's response to that, well, her filing says, quote, Jimenez versus Chavez reversed and remanded the state discovery violation, the importance of the evidence, 2, the surprise or prejudice of the opposing party, 3, violation was motivated by bad faith, and 4, any other relevant factors. In addition, the disclosure is no later than 30 days before trial. Failure to inform and controlling evidence and the prosecution's duty to present all material evidence was not fulfilled and constitutes a violation of due process. Materiality standard for Brady claims is met when favorable evidence could reasonably be taken to put the whole case in a different light as to undermine confidence in verdict. Brady violation occurred during undisclosed evidence revealed when prosecution introduced in trial testimony that knew or should have known is perjured. Files v. Whitley. And 1995, as she states case law, in U.S. v. Bagley, the Brady rule required prosecutor to disclose favorable evidence if suppressed deprives the defendant to fair trial. Impeachment evidence as well as exculpatory evidence falls within Brady rule. The government's failure to assist defense by disclosing info that is helpful in conducting cross-examination is a constitutional violation which deprives the defendant a fair trial. End quote. Once again,
Where?
not a lot of periods. I think there's quite a few punctuation marks missing. Words out of place. It's confusing. The fourth reason is what she claimed was prosecutorial misconduct. Lori claimed a number of things rose to prosecutorial misconduct in her motion, original motion, including claiming that Captain Keller made a statement that was irrelevant and prejudicial, claiming that Trina said false things in her closing arguments, such as stating that Lori wasn't entitled to a self-defense claim, while the jury was handed self-defense instructions, or that Alex Cox had no reason to be at her house, or that Lori told him to bring a gun. She also essentially accused the state of editing out parts of her police interview that showed her having emotion. Again, she really wanted that Kleenex waving moment included. The state came back recently saying there was no prosecutorial misconduct at all. But Lori has come back, doubling down now in her response here today on prosecutorial misconduct. The motion states, quote, in U.S. v. Charlie, presentation of evidence is neither trivial nor fleeting. The evidence comprised nearly the government's rebuttal case. The government continued to highlight prior incident in closing arguments. It is impermissible for the government to argue in closing that such evidence reflects the defendant's character. Error is not harmless as to prosecutor's failure to provide reasonable notice of its intent to use other acts evidence. The defendant was not able to investigate the evidence and prepare cross-examination of rebuttal evidence. Rules of Evidence 404B. In the matter of Martinez, the conduct of an attorney who, as a prosecutor, made comments in closing arguments in which appealed to jurors' emotions and persisted with lines of argument which violate rules of professional conduct prohibiting lawyers from engaging in conduct that is prejudicial to the administration of justice. In State v. Murray, a prosecutor's single unobjected to misstatement of the reasonable doubt standard constituted prosecutorial error. Prosecutorial misconduct is not merely the result of legal error, negligence, mistake, or insignificant impropriety, but taken as a whole, amounts to intentional conduct which the prosecutor knows to be improper and prejudicial. A defendant is denied due process of law when a prosecutor knowingly presents false evidence, whether it be by document, testimony, or any other form of admissible evidence, which is not limited impeachment. Yeah, end quote. That end quote. And again, hard to understand. And for her final reason, which she initially claimed was the court's lack of impartiality for striking her witnesses and Judge Bresky making his famous one-liner during the trial, which was, quote, I guess to the extent that you are comparing yourself to these biblical figures, I will allow it. But now, Lori is bringing up her main argument she had for Judge Bresky last week, that he denies promotions all the time. Most of you remember last week's hearing, but it truly was unforgettable. I was there, and it was so intense. Let's just replay the clip one more time here. Take a listen.
Your Honor,
Yes.
I have to ask that you would recuse yourself from the obvious personal bias that you have against me and send us to master calendar for this scheduling of a trial.
Really?
And what personal bias is that?
A lot, obviously, the personal bias that you're showing right now and that you've shown on the FTR several times during the trial.
Okay, well, I don't have any personal bias. All right?
Excuse me.
I've over-accommodated you on when you have to disclose
Way
things.
more than
In fact, your expert
over-accommodate.
should be summarily precluded today, and I haven't done that. So,
You denied every single one of my motions since for a year and a half that I've been here. Every single one of my motions has been denied. And have any of those motions not have merit? You've denied
Your
every
motions
single
have
motion.
no merit. And that's why they've been
this
denied.
morning, about 15 minutes ago, when I granted your motion to meet with your attorneys over lunch hour. I have granted other motions of yours. Okay?
This is the first motion that you've ever granted
Well,
in my behalf.
file motions that have a legal basis, and I might grant them.
So you're saying none of my motions have had merit.
None of them.
Not many, no.
And none of the motions that my first team, you denied every one of my first team's motions, you denied every one of my second team's motions, and now you denied every one of my motions until today.
I haven't denied every one of your motions.
Every single one of their motions was denied, every single one of the second team's motions were denied, and online. So you didn't come into this with any bias against me in the first place?
Again, file a motion that has legal merit. Okay?
And none of my attorneys ever filed a motion with any legal merit?
They filed a motion on your behalf, the first team, to preclude media coverage, and I issued my ruling according to the law. Right? They filed a motion to have you dressed out, not in jail clothes during hearings like this. Okay? That was not based in law. I denied that motion. So, I've ruled on the motions as required by law.
Without any kind of a conclusion of law in them, just denied. Does that not show a bias and a prejudice against one single person?
Shut up, Lori.
Are you not going to recuse yourself?
No, I'm denying your motion.
As he should. As he
Fast
should.
forward to this filing, it just came down. But while it just came down tonight, this was actually filed the same exact date as this argument in court, despite it not hitting the docket until late tonight. This time, her argument states, quote, the state is misleading the facts that Judge Boreski deprived the defendant almost all motions filed to the courts. The defendant was denied most of her witnesses. As a review will show, just cause that the state's intent is to deceive the public and the courts.
Really?
That's bold. The state only addresses two potential witnesses, Mr. Eaton and Mr. Boudreau. The defendant had 12 witnesses. The Supreme Court will overturn the court's determination if it proves to have been a clear abuse of discretion. The court has to show beyond a reasonable doubt that it did not contribute to or affect the verdict. No man can be a judge where his own interest is in the outcome. Critical decisions were set in motion, and by the judge not recusing himself was a violation of due process. Judge Boreski violated the Code of Judicial Conduct, Canon 1 and 2, that states that a judge shall not by words or conduct manifest bias or prejudice or engage in harassment. Conduct that compromises the independence, integrity, and impartiality of a judge undermines public confidence in the judiciary. The judge's blatant comments of this defendant's religious beliefs is also a violation of the Religious Freedoms Restoration Act. A judge who manifests bias or prejudice in proceeding impairs the fairness of the proceeding. The judge knew or should have known action beyond judge's lawful power and involved actual malice motivation, or if acts are intentionally committed with lawful power of a judge but for corrupt purpose, end quote. Whoa. So those were some really bold claims. So I have a genuine question. How should the state address each and every witness of Lori's when Lori refuses to give any information about why the witnesses might actually be relevant to the case? And even at last week's hearing, when she let the court know that she wanted to call Melanie Gibb and Zulema Pastenis as witnesses, she couldn't give one sliver of why they were on her witness list and how they were relevant to the case. And trust me, I can think of numerous reasons why both Zulema and Melanie Gibb would be relevant. I was rooting for Lori to just give one little crumb of relevancy, but she didn't. She often actually seems angry that Judge Boreski asks her about her witnesses and their relevancy, but now she is angry that the judge didn't ask about all of them. So also, if memory serves me correct, prior to the trial, Trina Kay said that she had no issue with some of those witnesses, which included Lori's sister Summer Shiflett, as well as Lori's mom and Lori's father, Barry Cox. So again, why would the state need to address them if they have no concerns about them? And let's not forget that Lori didn't even call any of her witnesses when she had her chance to do so. She chose not to put on a defense or call any of the witnesses that even the prosecution said she could absolutely call. I do want to bring up that in Lori's original motion, she stated, quote, part of the state's case was to establish that this defendant had stepped outside the Mormon religion by claiming she was a translated being, specifically in text messages saying she would be like Nephi, and that these messages were nothing more than part of the conspiracy to kill Charles Vallow. This defendant attempted to establish that being translated was a regular part of the Mormon religion and thus a relevant line of questioning, end quote. But it seems like now, based on her first paragraph about Trina Kay, she is essentially saying that the state has zero right to talk about or question her religion. So I guess while she was fine with them doing that during the trial, when she could cross-examine the witnesses, while snagging the latest gossip from her friends in a roundabout way, while at the same time questioning them about religious beliefs, now that she's lost her case, they were completely wrong to violate her religious rights by bringing it up. Make that one make sense. This filing ends with a paragraph that states, quote, this defendant requests a new trial based on the above fact finding to support this defendant's request. The state failed to produce factual support to their claims. The court and the state failed to investigate juror misconduct. The state failed to correct false evidence and false testimony. The state's ballistic expert was unqualified. The state is in violation of prosecutorial misconduct. The courts are in violation of Code of Judicial Conduct Canon 1 and 2, violation of the Religious Freedom Restoration Act, religious prosecution, and abuse of discretion 28 USCA 445B1. The judge made various improper substantive and procedural rulings directly to the merits of the case, end quote. I actually do appreciate that final paragraph. She sums it all up. Those long, winding sentences that didn't make sense, the missing punctuation. Here's what Lori is saying, that the state failed to produce factual support for all of their claims in their response to her motion. The court and the state failed to investigate juror misconduct. She's saying, as in other words, citing the Hidden True Crimes podcast over just maybe investigating and bringing Carl into questioning. The state failed to correct false evidence and false testimony. The state's ballistic expert is unqualified. By the way, that's been gone over multiple times. The courts decided that he is qualified. The state is in violation of prosecutorial misconduct. The courts are in violation of Code and Judicial Conduct Canon 1 and Canon 2 and violation of the Religious Freedom Restoration Act. So there you go. That's what she's saying, as well as the judge making wrong procedural rulings directly to the merits of the case. End quote. That is it, in summary. Too long, didn't read? There you go. That's what Lori is saying. Not thinking that this is going to go far. I'm curious how the state is going to respond. Prosecutor Frida Kay always responds methodically and with evidence, and I'm curious what is going to be in the response to this response. For those that want to read that response yourself, we will have that at patreon.com/hiddentruecrime. That is already posted. You can head there to read this on your own and maybe make it make sense more than I made it make sense. I just also want to say thank you for subscribing, because your subscription makes us even more reputable, and thus in turn makes Lori even madder. So isn't it worth subscribing? I also just want to say that we're going to be covering this trial in person in Maricopa County. We are heading there soon to Arizona. May justice be served. Thank you for following along.
Alright. And I got one more clip for y'all. This is the last clip. Should be about 20 minutes, give or take.
Hey everyone, big news. Sorry, let me get this on. Sorry about the shakes. Everybody there? Everybody there? Big news. Okay. All right. Let me make sure I can see the chat. Hey guys. It's good to see everybody here. All right. The chat is flying. And I can't go in and change it right now, so I hope that it's slow enough, because happy Friday, everyone, except for Lori Vallow Daybell, because I'm pretty sure she's not having a good Friday after Judge Boreski responded to all of her motions. The judge himself has now responded to Lori Vallow Daybell. So, we're going to read this together, and yes, this is called, thanks guys, this is called On a Whim Live. I have some place to be in an hour. I'm at one appointment. I jumped in the car. It's hot out. I've got both doors open on either side of me to let some wind in, but the car's off so you guys can hear me, and we are going to break this all down. Let's go. Let's go. So, here we go. Judge Boreski came down the docket. First off, he is going to break down each thing that she requested. The first is the court has received and reviewed the following: defendant's motion for a new trial, filed May 1st, 2025, the state's response in defendant's motion for a new trial, filed May 6th, and the defendant's reply to state's response to defendant's motion for a new trial. Boom, boom, boom. All right. All right. So, first off, lifting, you know what? The wind tunnel's not working. We can't hear anything. So, I've got one door open. All right. That's enough. Lifting of the admonition. Oh, here we go. Sorry, I jumped ahead. The court will address the issues in order which will appear in the defendant's motion. Number A. Letter A, juror misconduct. The defendant alleges there was juror misconduct based on a statement Juror 15 made to reporters following the verdict, wherein he stated, You know, I feel very sorry for her. Driving home yesterday, I was like, God, she's spending the next 3 years, 3 lives in prison in a cell, end quote. On its face, the statement would seem to indicate the juror violated the admonition and researched the defendant's acquiring knowledge about her sentence imposed in another matter prior to the lifting of the admonition. However, the state's response included multiple additional media clips of statements Juror 15 made both immediately prior to and after the statement referenced herein, of which he denies any knowledge of the defendant's other case sentence prior to the court releasing the jurors from the admonition. At best, Juror 15 gave a single statement, which seems to be in conflict with all of his other statements, which he specifically denied any misconduct. Here, on the limited record of the pleadings before the court, there being no affidavits or sworn testimony evidencing any misconduct as contemplated by Rule 24.1, the court does not find a clear indication of juror misconduct, let alone any evidence of prejudice to the defendant. Juror misconduct requires a new trial only if the defendant shows actual prejudice, or if it can be fairly be presumed from the facts, and then
Exactly.
the case law is cited. So in other words, he clearly had no prejudice if he was considering that Lori Vallow Daybell was perhaps not guilty. And there is no prejudice of this defendant, thus there is no juror misconduct. B, preclusion of Tylee Ryan and Alex Cox's statements and impermissible testimony by Detective Daniel Coons. Now remember, Detective Daniel Coons, he was the ballistics expert witness. She does not think he should be an expert witness, and she is upset that Tylee Ryan and Alex Cox's statements were precluded from being able to be part of, her testimony or evidence in trial. So, Judge Vareski's response. I love it. We have over 2,000 people in chat. If by chance Troublemaker Baker's here, which she probably isn't, she had no idea I was going live, if we could slow down the chat, but we're going to do this. Oh, it does look slower. Maybe she slowed it down. Thanks, guys. All right, conclusion of Tylee Ryan and Alex Cox's statements of impermissible testimony by Detective Coons. The court issued a preliminary pretrial ruling on March 11th, 2025, regarding the inadmissibility of statements made by Tylee Ryan and Alex Cox, and that is true. I was at that preliminary pretrial ruling hearing. Sorry, can't happen. The court's ruling stated that out-of-court statements made by Tylee Ryan and Alex Cox were hearsay, and a defendant failed to establish that any specific statement was either non-hearsay or fell within an exception to the rule excluding hearsay. The court went on to give the defendant the opportunity to offer specific statements at trial by stating that the defendant could re-urge the issue outside of the presence of the jury. Not only did the defendant never take the court up on its offer during trial, the defendant's motion for a new trial reply only argue in generalities, failing to set forth any specific statement that should have been admitted into evidence under either a non-hearsay exemption or an exception to the hearsay rule. I mean, I love it. Judge Boreski talks exactly like he talks in court. Like, look, hey, let me walk you through this. We need some specifics, not just generalities. But hey, you can bring this up, Lori. Here you go. Let me spoon feed you. I love it. He's like, so let's remind you one more time what was said in that pretrial hearing. So let's keep going. As to Detective Coons' testimony, the defendant argues that the detective did not have foundations to testify as an expert. Sufficient foundation was laid for the Detective Coons, to give his opinion on ballistics again, and the defendant has offered no specific information as to what additional foundation should have been required. So in other words, on the stand, Detective Coons in his testimony laid foundation as to why he would be an expert in his specific testimony. It was laid, it was great. And the defendant, who is Lori Vallow, offered no specific information as to what additional foundation for him to be an expert would have been required. To the extent the defendant, Lori, believed the witness was not qualified. That was the only reason she gave, that he was not qualified. But Lori, we need just a little bit more, the judge is saying. Give us something. So, or her opinion, unless she gave us more, should not be given weight by the jury. She did have the opportunity to cross-examine this expert witness about his qualifications or lack thereof, as well as the basis for his opinion. But she didn't do that. She didn't do that, in other words. The defendant also argues that she did not have time to rebuke Detective Kuhn's testimony. The record is clear that the defendant was offered more time to prepare for trial. She was offered a continuance, but she declined. She was not going to waive her right to a speedy trial. Moreover, the argument that the basis of Detective Kuhn's testimony was the walkthrough of Alex Cox's house is not supported by record. In other words, he didn't testify to that. The defendant's reply, for the first time, Lori Vallow's reply for the first time, very first time, raises the additional argument that Tylee Ryan's statements also form the basis for Detective Kuhn's testimony. Again, there's no evidence of this, and the defendant offers no specific statement by Tylee Ryan or Alex Cox to support her assertion. Even if what Alex Cox and or Tylee Ryan told Detective Kuhn somehow contributed to his opinion, the defendant never asked the detective those questions. Or did anything Alex Cox show you? In other words, now this is funny. Judge Brusky is laying out a question that Lori could have asked. Like this. He writes, i.e., for example, here's a question, Lori, you could have asked. Did anything Alex Cox show you or tell you contribute to your opinion? Question mark. This type of question, Lori, would have been permissible. However, the defendant, Lori Vallow Daybell, did not ask it, or nor was ever precluded from asking that. The court finds the statements of Tylee Ryan and Alex Cox were properly excluded, and the defendant has failed to raise a single specific statement that should have been allowed under the rules of evidence, nor does the defendant establish Detective Kuhn's testimony was improper. So, there you go. Like, Lori, you could have done this. Lori, you could have done that. Lori, you could have asked this. Lori, you could have asked that. You didn't do any of these things. Now, there's also a footnote at the end of this page that I just skipped, which actually takes us back to letter A. The juror, the single statement from the juror, Coral, juror 15. So, those footnotes actually I think are kind of important, so I'm going to now step back a little bit. Let's read these footnotes. Number 1. So back to juror misconduct really quickly. If there were misconduct, the defendant's own motion undercuts her argument that prejudice exists because she points out that juror 15 stated he was leaning toward not guilty throughout deliberations, a distinct indication that if juror 15 did have any extraneous information at that time, it did not affect his consideration of the evidence. Number 2 in the footnote about jury misconduct. Neither the state nor the defense chose to have an affidavit prepared by juror 15 or any other juror. So the court is left with the media clips provided in the pleadings. In other words, the court is, that's great. Let me read that one more time. Neither the state nor the defense chose to have an affidavit prepared by juror 15 or any other juror, so the court is left with the media clips provided in the pleadings. It's hidden true crime. So, glad we could help out there, as well as Coral explaining. So, C, discovery violation. Discovery violation. Although defendant's motion alleges the contents of the hard drive are exculpatory, she never articulates a single item whatsoever that would constitute exculpatory evidence. So in other words, we're jumping to the fact that Lori complained and has whined over and over and over again that if she could get her own extraction of Charles Vallow's phone, of her late husband's phone, that she's now convicted of murdering, her murdered husband's phone, that it would be evidence so damning, it would pretty much mean she was innocent of this crime. It's so extreme that the judge said, look, the evidence is so compelling, according to Lori, that the judge was like, do you want to do a continuance on this trial then? Do you want to wait till you get Lonnie Dworkin to be able to testify and we get this evidence that you say is that good? And Lori was like, no, let's move forward. And the judge gave her all the opportunity in the world to get this own extraction of Charles Vallow's cell phone. Didn't happen. Mid-trial, the judge was like, too late. So now she's saying there was a discovery violation because she couldn't get this extraction in time because it would have meant she was innocent. So the judge is addressing this and saying, look, you have never, Lori, been able to articulate a single item whatsoever that would constitute exculpatory evidence, not once. And the judge says, again, merely stating something is exculpatory does not make it so. I love this judge. I mean, it's true. He's speaking truth. He's dropping truth bombs right and left, but he's talking. He's like, let me put this to you in the most simplistic terms, but welcome to Lori Vallow Daybell's mind. Just because you say something doesn't mean it's true. And the judge is spelling it out. But this is essentially who Lori Daybell is. She really believes that if she says something or she thinks something, it's true. Right? Like, that's what kind of, like, drives us all crazy. And this is no different. And the judge is, like, laid it out. Just because you say that this evidence would claim you're innocent doesn't mean it's true. Give me something. So, here we go. She never articulates a single item whatsoever that would constitute exculpatory evidence. Again, merely stating something is exculpatory does not make it so. The defendant's request for additional discovery relates to Charles Vallow's phone, and this was accommodated. The state has previously disclosed all evidence it had in possession at that time. In other words, Lori was given all of discovery. The defendant requested access to the actual phone to run her a new examination with software that has been updated since the phone was examined several years ago. The defense has offered no evidence that any additional information was obtained from the phone, let alone it being exculpatory. In other words, she was given the phone. Go for it. Do your own. Let's figure it out. Nothing. Nothing has come from this. The court finds no discovery violation. Yeah. Now, here we go. Prop D. I keep wanting to say number D. Letter D. Prosecutorial misconduct. Let's hear what Judge Borowski says about that. The court finds nothing in the defendant's allegations comes close to prosecutorial misconduct. The state is allowed to argue reasonable inferences from the evidence presented. The defense does not have to agree with those inferences and is permitted to argue the evidence should be interpreted differently. I love it. Hey, by the way, Lori, you do not have to agree with the state and those inferences and is permitted to argue the evidence should be interpreted differently. The defendant, Lori, argues in her reply for the first time that both the state and the court violated the defendant's right under the Religious Freedom Restoration Act, the RFRA. And although new arguments are not to be considered when first raised in a reply, the court will nonetheless address this. The RFRA protects religious freedom and prohibits the government from substantially burdening a person's exercise of religion. Right, exactly. Right. It protects religious freedom. The Religious Freedom Act does that.
Yep.
But there's no conduct by either the state or the court that somehow infringed on the defendant's freedom to practice her religion. Nor is there anything about the trial that impacts the defendant's freedom to believe whatever it is she chooses to believe. Moreover, the Religious Freedom Rights Act does not protect someone from committing criminal acts in the name of religion, nor does the act prevent any person from disagreeing with another's belief system. So in other words, we can disagree with your belief system, Lori. You don't have to be right, and you don't get to be protected from committing a crime. Here, different witnesses may have had different interpretations regarding who Nephi was, or the significance of Nephi's story. The defendant had an opportunity to cross-examine those witnesses regarding the same. None of this infringes on the defendant's religious freedom. For those reasons, the court finds no prosecutorial misconduct. E. Court's lack of impartiality. The defendant alleges the court was not impartial because the court struck 2 of the defendant's witnesses from the defendant's witness list. Contrary to the defendant's assertion that no rule or law or evidence requires her to establish a witness has relevant information, Arizona Rules of Evidence 601 and 602 require just that. Prior to trial, the defendant was given an opportunity to make a general offer of proof as to what relevant information the witnesses would provide, which the defendant was unable to provide. I saw that firsthand. He was like, how are they relevant? She wouldn't say a dang thing. The defendant was unable to provide this, and when the court precluded the witnesses, the defendant was also advised by the court that during the course of the trial, if she believed these witnesses had relevant information, the court would revisit the issue.
Exactly.
After the defendant did not again offer any witness, even though she was specifically told she could re-urge the issue. And I was there. The judge said that. You bring it up. In addition, in her motion for a new trial, the defendant offered no further information on what testimony the witnesses would have given if they were permitted to be called as witnesses. The defendant also argues the court demonstrated a bias based on the court's comment made while overruling the state's objection during the defendant's questioning of Serena Sharp. The state was objecting to the relevance of the question of the court, and the court thought the question had some minimal relevance based on the context of the defendant's line of questioning. The court notes the defendant's argument as to why the question was relevant was not in line with why the court surmised it was relevant. While the court's comment was not necessary, it does not evidence bias, nor does it mean the court was demonstrating any partiality. Nonetheless, the court acknowledges the court's comment was unnecessary. That's the win for Lori. And the court should have simply overruled the state's objection without comment. Okay. Now, what we're talking about, for those that remember, is when Judge Boreski stated, in regards to you comparing yourself to religious, prophets, I will allow it. The judge is saying he should not have made that comment. He should have just overruled the state's objection without comment. Moreover, the court has been presented no evidence whatsoever that this comment influenced the jurors. Having carefully considered defendant's arguments, all of the briefing and the record, the court finds the defendant received a fair and impartial jury trial, and the defendant has failed to establish any ground for a new trial under CRIMR 24-1C. It is ordered denying the defendant's motion for a new trial filed May 1st, 2025. There are a couple other footnotes. Let's read them together. There's a footnote to this specific thing. Footnote 1, the defendant's reply seemed to argue that the defendant was precluded from calling all 12 of her witnesses, which is not the case. The defendant chose not to call any witnesses during the defendant's case in chief. Exactly. So she's upset that certain witnesses were precluded. She did not call any witnesses in the end. She didn't put on a defense in the end, if you all remember that. Like, in the end, she was fighting to have witnesses, right? For this trial where she was just convicted of murder. She wanted witnesses. And in the end, she didn't call any witnesses. And now that she has a conviction, she wants to argue that It wasn't fair. Lori. Let's see if I missed any other footnotes. I think I got all the footnotes. Okay. So, yeah. I'm going to check out chat now. I've got to go right back in. It's busy Friday. I thought I'd be like taking a little break from going live because if you don't recall, 2 days ago I went live saying thought I was done with Lori Vallow for the week, and then yesterday I went live thinking thought I was done, and the docket just keeps bringing in. Judge Boreski, oh my, when I read that I was like, I've got to go live right now. Between appointments here. Looking at what you're saying. It isn't that Lori doesn't want to call witnesses in to vouch for her. The problem is that nobody wants to come to court and do that, including her own mother and sister. It's a good question, you know? Who doesn't want to come? And yeah, a lot of people don't want to. And, you know, it's also, she's admitted it. It's a game of cat and mouse. So let's say she can call some witnesses. What are they going to say? You know? It's interesting. All right, guys. I'll try to maybe even go live later tonight. Hit notifications because I might bring us some more tea later tonight. There's more coming down, and we have some updates on Coburger, as well as I'll just say a lot more. Oh my goodness, Jen, thank you so much. I needed that. I've also got to start putting my phone microphone in my purse. Where I probably don't like purse.